Section 376DA was inserted by the Criminal Laws Amendment Act of 2018. This section is essentially a subset of Section 376D. It concerns a woman who is under 16 years of age at the time when she is subjected to gang rape, and every person who is deemed to have committed the offense of rape under this section shall be punishable with only one type of punishment, and that is life imprisonment till the end of that person's natural life along with fine. Here also the fine shall be just and reasonable to meet the medical expenses and rehabilitation of the victim, and this fine shall be payable to the victim. Section 376DB is also a subset of Section 376D. It concerns a woman under 12 years of age. Where a girl under 12 years of age is raped by one or more persons constituting a group or acting in furtherance of a common intention, then each of these persons shall be deemed to have committed the offense of rape, and each of these persons is liable to be punished with imprisonment for life, which shall mean imprisonment till the end of his natural life along with fine. Here the extreme penalty of death has also been prescribed. So any person who is found guilty under Section 376DB is liable to be punished with death penalty. Here also the fine shall be just and reasonable to meet the medical expenses and rehabilitation of the victim, and the fine shall be payable to the victim. Summing up, we can say that there are three provisions of law prescribing punishment for offenders of gang rape. Persons who are deemed guilty of the offense of gang rape are punishable under three different sections. Where the woman involved in the offense of gang rape is under 12 years of age, then the provisions of Section 376DB will be applicable, and the offender is liable to punishment to the maximum possible extent. The extreme penalty of death is applicable to an offender under Section 376DB. If the woman involved in gang rape is between 12 to 16 years of age, if she is 12 and above but less than 16 years, then the offender involved is liable to punishment with imprisonment till the end of his natural life. Where the woman involved in the gang rape is 16 and above, the person found guilty of committing gang rape is liable to be punished with a minimum penalty of imprisonment of 20 years, and the maximum is imprisonment till the end of his natural life. Section 376E deals with repeat offenders. This section is applicable to a person who had been previously convicted of an offense punishable under Section 376, 376A, 376AB, 376D, DA or DB. If such a person is once again convicted of an offense punishable under any of these sections, then this time he is liable to be punished with imprisonment till the end of his natural life, or even with the extreme penalty of death. We can now sum up all the provisions relating to rape. The offense of rape has been defined in Section 375. The definition was overhauled and was made comprehensively wider by the substitution made in the year 2013. It now includes not only sexual intercourse but numerous other acts, including insertion of finger or an object. The offense of rape is punishable under 9 different provisions of law, starting with 376(1). These 9 provisions prescribe different punishments for different categories of rapes. The punishments start with Section 376, which has 3 subsections, followed by 6 other sections starting with 376A. Of all these 9 provisions prescribing punishment, 4 prescribe the maximum or the extreme penalty of death also. These provisions are Section 376A, 376AB, 376DB and 376E. All other provisions also prescribe severe penalty. The minimum penalty under any of these 9 provisions is imprisonment of 10 years. We shall now have a short discussion on the age of consent for sexual intercourse. Under the present law, there is no age of consent for sexual intercourse for a male. A boy of 14 years of age, 16 years of age can take part in sexual intercourse with his consent. But for a girl, the minimum age is now prescribed at 18 years under Section 375. If a girl under 18 years of age takes part in sexual intercourse, it is an offense. Interestingly, it is not the girl who is to be punished for this sexual intercourse. It is her partner. Even if the partner is mature, he is liable to be punished. Even if he is a minor, he is liable to be punished. Section 375 prescribes the age of consent for girls for sexual intercourse as 18. What should it be? Puberty is the process of physical changes through which a child's body matures into an adult body capable of sexual reproduction. Puberty usually occurs in girls between the ages of 10 to 14, while in boys it generally occurs later between the ages of 12 and 16. On one side of the spectrum, there are people, including our legislators, who subscribe to the view enacted in Section 375. But on the other side of the spectrum, there are people who say that there is no need to interfere in the law of nature. When Mother Nature herself prepares a girl for sexual intercourse by the age of 14, why should there be a law which prohibits sexual intercourse by a woman until she attains the age of 18? So this is the question. Why should sexual intercourse with a woman under 18 years with consent be a crime punishable with rigorous imprisonment even up to life? This question is meant to serve only as a food for thought.